Now that Representative Mitchell's here, we'll begin. Calling back to order the General Government Appropriations Subcommittee. Appreciate everyone being here. Committee before us today, we have two resolutions to discuss. 901 and 902, I believe. Chair Lady Dempsey is here, and whenever she is ready, we will have her come forward. Wherever you're most comfortable, you can be here at the table. Gentleman's not recognized.
Good afternoon. I know y'all have had a long morning, but I do appreciate you pausing to listen to this. I want to tell you, first of all, just thank you. Thank you for the opportunity. But also, in appropriations, at times we have had a small committee that looked at this and on these compensation requests, and I have sat on that 2, maybe 3 times. So I know how hard it is to listen and to realize what you are holding in the grasp of your hands as far as decision making goes. This is personal, though. I want y'all to know this. This is from my community. My community is relatively small in the scheme of things. When I first looked at this, I realized that I knew almost every law enforcement and judicial person that touched each of these cases. Some are not alive anymore, but I know them, and it breaks my heart to know that this actually happened in our sweet town. So I've had the privilege to represent the citizens of Roman Floyd County for over 18 years, and I've been particularly honored to be able to serve and help underprivileged and marginalized Georgians in my community and around our state. When I was asked to consider sponsoring the claims for Lee Clark and Joey Watkins, 2 men from my community wrongly convicted and incarcerated for over 20 years, I felt compelled to assist. When I was asked to help late last year, Mr. Clark and Mr. Watkins' cases were not unknown to me. Each case had been reinvestigated as the subject of podcasts that were followed closely in our tight-knit community. I'd heard their stories, followed their cases, and I was and am eager to help right the wrongs committed against them. As the attorneys will discuss that follow me in more detail, Mr. Clark and Mr. Watkins were wrongfully convicted and incarcerated due to false and misleading testimony offered at trial, withheld evidence, and misconduct on the part of public officials and jurors. Due to these wrongful actions on the part of the state, the court has already determined that their convictions cannot stand. They have been exonerated in every sense of the word. For their part, Mr. Clark and Mr. Watkins maintained their innocence throughout. And despite years spent in prison for crimes they did not commit, they have emerged not bitter, but with humble and grateful hearts. Both are working and trying to adjust to a world that has changed much since they were locked away at such a young age. But their wrongful incarceration denied them the opportunity to build families, careers, and financial futures for themselves and their loved ones. We, as a state, sadly, denied them those things. I believe that when the state causes harm, we have a responsibility to compensate those harmed. That's why I agreed to sponsor these claims, and while no amount of money can compensate Mr. Clark and Mr. Watkins for the years they lost due to their wrongful convictions and incarceration, we owe it to them to provide resources to help them move forward and care for themselves and their loved ones. I hope you will agree with this as you evaluate their claims. I know that each of you have some information in front of you about each of the different resolutions. I do want to tell you that in the information that you have, not in the official resolution, there is a date that is wrong just on that summary page. It says 1986, and this is referring to Mr. Clark's. This is in 901. It should say 1996, as it does in the resolution. There is also a Scribner's error that appears in Mr. Clark's name. Darryl is spelled D-A-R-Y-L, not D-A-R-R-E-L-L. So those, while the information for the year 1996 is correct on 91, his name appears wrong. Those are two issues that I would like for y'all to look at and make sure of. I want to tell you that when I spoke and first heard these cases, and this is my first time, and I will tell you I'm a little bit nervous about it, because it really is. It's a very big thing for us to consider. When I spoke to the Claims Advisory Board, I felt even more compelled after that. I understand the responsibility and why their letter comes to you of recommendation, just as it does, because it is not in their jurisdiction to make these decisions, but it is in ours as legislators to look at that and to see if we feel there's a way to help them heal and continue to move forward and have full, meaningful lives. I thank you, and now I think you will hear from the attorneys representing them.
Before you leave, just for one quick point of clarification, because I am seeing multiple spellings on multiple sheets. Just one more time for clarification. One R.
It's D-A-R-Y-L, and he actually goes by his middle name, Lee. But on all documentation, that is a Scribner's error that occurred in the resolution drafting. And then the other is simply on the document that you each have that is a summary for 901.
Understood. Representative Mitchell, do you have a question for Ms. Chair Lady Dempsey, or do you want to wait for?
I can wait for the president.
Thank you. Thank you.
Thank you.
Next up. And just to make sure we're all on the same page, we are starting with HR 901. Thank you.
Good afternoon. My name is Paul Murphy, and I'm an attorney for Mr. Darryl Lee Clark, who is sitting here to my left. It's my honor to represent Mr. Lee Clark in his efforts to obtain compensation for his wrongful imprisonment. Our goal and our purpose in seeking support of this resolution is to compensate an innocent man, Lee Clark, in an amount of $1,840,715 for the grievous injuries and deprivations he suffered during his wrongful incarceration in Georgia prisons for a death he had nothing to do with. He was imprisoned for 25 years for a crime that never happened. He was imprisoned for murder, and there was no murder that took place. I'll give you a little bit of background on this. In October 1996, a 15-year-old boy, Brian Bowling, died from a self-inflicted gunshot wound while playing Russian roulette in his bedroom with his friend Josh Story. the 17-year-old, then 17-year-old, Lee Clark was nowhere near the bedroom and had nothing to do with this death. He spent 25 years in prison due to misconduct and wrongful incarceration at the hands of the state. You wonder, how could that happen when even the police, when they looked at it first, said that all the evidence looked to the fact that Brian Bowling died of a self-inflicted wound. It happened because at first there was extraordinary pressure put on the investigating officers, one of whom was involved in a romantic relationship with Brian Bowling's aunt, who pressured the police to pursue an alternative theory to an alternative reason for Brian's death, which resulted in conspiracy and murder charges. At trial, that detective manufactured evidence against Mr. Clark by making inaccurate and false statements involving a severely deaf, mute, and learning impaired individual who gave his testimony through sign language, his own unique sign language. He was not schooled in American Sign Language, but that testimony was interpreted by a person who was an American Sign Language interpreter. That led to quite a bit of confusion in the case, led into several wrong conclusions, and led people to believe that he was testifying that Lee Clark was at the scene at the time of Brian Bowling's death, which was not the case. But that same officer claimed that this deaf, mute, and severely learning impaired man, Charlie Childers, had identified Lee Clark in a police lineup before he had been arrested and had marked the lineup with an X. When a qualified interpreter spoke with Mr. Childers much later at the behest of the Proof Project, he said that he had never marked that lineup with an X. This same officer was involved in witness intimidation and coercion. He threatened and coerced a witness into giving false and perjured testimony. The person who gave that testimony was a woman named Angela Bruce. She was threatened with having her children taken away from her if she did not cooperate. There were also Brady violations, where the state withheld information, first of all, from Charlie Childers 1 month before trial, when he told Detective Battle, the lead investigator, that he had not seen Lee Clark at the scene. Another was they neglected to identify an alibi witness who put Mr. Clark at his home at the time of Brian Bowling's death. There's also some interesting medical expert testimony that was given at trial. In particular, the court allowed the county coroner to testify as to the cause of death. The county, as you know, in Georgia, you do not have to be a forensic pathologist to be a county coroner. This man ran a funeral home. And all you need to be a county coroner is to be over 21, a citizen of the state, and not a felon. And that was his qualifications, that and a couple of courses that he took. But he was allowed to give testimony at trial as to the wound and suggesting that Brian Bowling had not taken his own life, but rather had been shot by Josh Story. That evidence ran against the qualified evidence of a true pathologist who said that that the wound was self-inflicted, and a neurologist who both testified at trial. When all this wrongdoing was brought to light, and it took 25 years, and the relentless investigation of the Proof Podcast and the Georgia Innocence Project, when that information was brought to light and to the Floyd County District Attorney, the District Attorney sought exoneration, and the Superior Court dismissed all the charges against Mr. Clark. We went before the Claims Advisory Board last week. You have their findings before you. They did a fine job of summarizing the case. And they also found that Mr. Clark presented a compelling evidence that he was wrongfully convicted of his crimes, and that he requested compensation, while admittedly far short of the actual loss of being put in prison for a crime he did not commit, is an appropriate amount should the General Assembly choose to pursue that compensation. But they said that they could not recommend it because there was limitations in their jurisdiction, and that there was no culpability for which they would attach to this incident with respect to a state agency. It's with respect to that I respectfully disagree. No one can honestly argue that a rightful imprisonment can flow from a wrongful conviction. In fact, we have created a whole body of law, starting with our Constitution, that's designed to prevent that very thing. Our Georgia Constitution mirrors the protections that are set forth in our Constitution to prevent that type of injustice. Our criminal procedures are designed to protect against the incarceration of an innocent man. Our courts are set up, and our appellate process is set up to prevent against the incarceration of an innocent man. In fact, but the resulting loss that they recognize is a loss of liberty rights. And it's so profound and manifest an injury that it is an injury per se. There is no getting around the point that the state has injured these people by imprisoning them when they had no fault. Our Eighth Amendment bans cruel and unusual punishment and insists that all punishment must be proportional to the crime that has been committed. When no crime has been committed, there is no proportionality. It is per se improportional and must be compensated. The act of incarceration of an innocent man robs him of his liberty rights and the pursuit of happiness. Justice is not served by exoneration. Exoneration of the innocent simply puts the victim in the position he should have been on the date of his incarceration, a free man. The state can never make the wrongfully imprisoned person entirely whole, but cannot escape the wrong suffered by the wrongfully incarcerated with exoneration of a simple apology. If that is all that is required, every indignity, deprivation, and injury suffered by an innocent man in the aftermath of a wrongful conviction is left unaddressed. We're in a situation where we don't have a specific statute that addresses compensation in Georgia. The absence of a specific statute providing for compensation of the wrongfully imprisoned is not and should not be an impediment to recovery. Georgia has an entire legal framework to protect against such injustice, which is found in Chapter 23 of our Georgia Code. More particularly, Georgia's embrace of equity to avoid injustice. The bedrock premise from which equity flows is that no one should be allowed to suffer a wrong or injury without a remedy, and that can be found at OCGA 23-1-3. That provision is not elective. Equity demands the wrong be righted through an appropriate remedy. Equity demands additional redress beyond exoneration for the wrongfully incarcerated to make him whole. I'm going to note that we send guilty people to prison to pay a debt that they owe to society. When an innocent man is sent to prison, society owes a debt to him. Here, it is impossible to restore Mr. Clark and, as you'll hear, Mr. Watkins' stolen youth, their lost experiences, their memories, their joys and loves. Similarly, it's impossible to undo the daily deprivations, dangers, despairs, and humiliations that they suffered through the manifest injustice of a wrongful conviction and the loss of their human rights. The law of equity, which this legislature has imposed upon all Georgians to protect against injustice, demands that no person should suffer an uncompensated wrong, and demands that Mr. Clark and Mr. Watkins be awarded reparations for what has been stolen from them. My wife asked me after I first took on this representation to tell me a little bit about Mr. Clark. And I subsequently also got to meet Mr. Watkins. And my impression was both of them are men of faith. They're strong and resilient. But this tragedy that befell them at the hands of the state also broke them. The state of Georgia broke Mr. Clark and Mr. Watkins once. Don't let it happen to them again. And I thank you. And I'd like to have Mr. Clark tell you a little bit about what it's like to live his life now that he's out of prison. Thank you.
Well, as Paul stated, I am a man of faith, and I have no doubt I'm sitting here before all of you today because of the grace of God. And I tell you though, since I've been out of prison now for a little bit over a year and maybe about 2 to 3 months. Since I've got out, while I was in there, my dad he'd all the time tell me, he said, you need to get prepared for what you're coming out here to. It's not what you left. And when he tell me that, I just think to myself, oh, it ain't as big as he's making it out to be. It's gonna be fine. I'm gonna be all right. I'll get out and be good. I got out. It's been everything but good. I'm a 44-year-old man, finna be 45. I don't have any experience in anything. Going into a job set, you're going into it. You'll have to excuse me. I'm not good with crowds. Going into job sets and trying to get myself established. I don't have any history. Don't know anything. So going into it, it's just, thank you. Going into it, you try to go into it with open mind so you can get into it and start learning everything. But for me, it's been a task. Unfortunately, when I come out to them prison walls, I also brought something with me, an anxiety, a bad anxiety. When I get into work environments and stuff, I try my best to get focused on what I'm doing, but my nerves get the best of me. I think it's what you call a post-traumatic stress disorder is the only thing I guess you can compare it to. And I'm trying to battle around that. I'm trying to get around that curve so I can get where I can learn more. And it's a slow process. I'm learning a little bit at a time, but it's not moving fast enough. I'm sitting here, I'm 44 years old. Like I said, finna be 45. 50's right around the corner. I mean, making the kind of money I'm making right now, 17 an hour. That's not gonna get me anywhere. I don't got the qualifications to make any more money. I've tried all I can do. I pray to God all the time, put my faith in Him. And even being a man of God, I sit back and at the end of the day, sometimes I wonder to myself, is it enough? I mean, is my faith strong enough? What am I doing here? I tell you, it's been really hard. It's been a daily struggle for me going in there, and people, especially when you're at my age and you're sitting there on a job and you can't do something, and people are looking at you like, man, you're 44 years old and you can't do this. You can't do this simple thing right here, really? What's wrong with you? Then you have to relive the harsh nightmare that was the past 25 years of your life. You got to tear that open again. Trying to sit there and explain to people, and yeah, some people get it, but some people look at you like, man, this dude is really, there's something really wrong with this guy. He's not right. And yeah, there's something wrong with me. Yeah, I missed 25 years of my life. That's what's wrong with me. I got a big empty spot right there. I don't have any kids in this world. Don't know that I ever have any. It's everything about all of it. I mean, it's the money I'm making right now. I couldn't afford a kid if I wanted one. That's the sad part. It's just, I mean, I don't know any more to tell y'all. I mean, I look at it like this. I view it like this. I mean, in the state of Georgia, they failed me one time, and it's my hopes, my praise that it won't happen again. I want to get on with my life. I want to have a life. I want to have something that I can just, it's theirs, it's mine. I want to have something in this world. I want to have a family. I don't know anything else to say. I mean, that says it all. I mean,
We're happy to answer any questions.
yeah, I'll be glad to answer any questions anybody's got.
Thank you. And thank you for being here. I've often, when we talk about this subcommittee, it's not really colorful usually. We're dealing with mundane departments that have 3 letters, DOL, DOR. This is my least favorite part of this committee is having to hear stories like yours, Mr. Clark. Certainly appreciate you being here and consideration. I'm sure we'll ask a few questions, but and we'll start. We'll direct this to your attorney. Just for clarification, how the compensation amount was calculated.
Thank you for that question. We looked at a number of different statutes where there were compensation schemes in place. And they ran anywhere from $50,000 a year for older statutes that may not have been adjusted for inflation to the present statute that's being presented to this legislature this year, which makes a recommendation if adopted for compensation running between $60,000 and $120,000. The federal statute provides for compensation, and that's annual compensation for wrongful imprisonment. The federal statute provides, I believe, it's $50,000 to $100,000. This amounts to about $197 a day, or a little over $8 an hour for wrongful imprisonment. And that's how we came up with that number. We're on the lower scale of the various statutes that we've reviewed. It's not a scientific number. In my mind, there's not enough money to compensate Mr. Clark for what's happened to him, and that if this committee sees fit to increase that amount, it would be a greater justice for Mr. Clark.
Thank you for that. Representative Mitchell.
Thank you, Mr. Chairman. First of all, Mr. Clark, I'm so glad that you're here, and as a law school graduate myself, I want to let you know that you have been well represented by your counsel. I think this and other similar cases just illustrates a flaw in Georgia law. I contend we should not even be here. The fact of the matter is, if we go down to the case support where it says, based on the evidence, the Floyd County District Attorney sought exoneration and Superior Court dismissed all charges freeing Mr. Clark. I think that should be the end of the story. If the courts have determined that he was wrongly convicted, the only issue then should be compensation. It's dictated that the lead detective was fired and decertified by post. That's good news, and the evidence that was entered today is further good news. But in my mind, this should not even be before us. We should have, as the attorney mentioned, we should have a system by which, if you're found to be innocent, the state exonerates you. Then we should have a formula for calculating what is just compensation. The board notes that the General Assembly is not subject. They denied his request for compensation, but it's important to point out to you that the board knows that the General Assembly is not subject to the same statutory limitations as the board, nor is the General Assembly bound by this board's recommendation. So I would recommend, if I could, I'd go higher myself. But I would recommend that we give Mr. Clark the full $1,840,715 for the grievous injuries and deprivations suffered during his wrongful incarceration. I personally think I can speak for every single one of you on this committee that you would not trade 25 years of your life for $1.8 million.
Thank you, Representative Mitchell. Shirley Smith.
Thank you. First of all, you did an excellent job talking to us as a committee. I know how hard that was, and you can tell you have our sympathy. I'm going to ask a couple of just technical questions of your attorney for some clarification, if I'm not against you, but just understand it. The first one, I'm curious, even though the board cannot address a local county or a police department, is there another avenue to bring this redress issue before the county government or the police department? Is there another avenue to explore here? Because sometimes these issues come to the state, and I read the reason why the board made the decision it did, but I'm just curious, are they protected, or what exonerates them at the scene of this misgivings here? What explain that, if you would,
Well,
sir.
Representative, there's nothing that forecloses a possible action against the local authorities for this type of injury, but it would also have to be, through some sort of federal claim, I believe. I'm not an expert in that arena. There's dangers associated with that. For example, Tolliver County had a big judgment against it, and as a result, it was in a position where it could no longer perform trash pickup. So there's certain dangers that are associated with that type of cause of action, and the uncertainty, and it also presupposes that the wrongful imprisonment is not a separate and compensable wrong. There is the wrongful conviction, but there were two wrongs. There was the wrongful conviction and the wrongful imprisonment. And the local authorities, had no hand in the imprisonment other than being the agent that brought it about. But the state's reach into all of this is profound. The investigation is done under state law. The district attorney is an officer, a constitutional officer. The judge is a constitutional officer and partially compensated by the state. the prison system, the courts of appeals, every part of the criminal justice system which is implicated in a wrongful imprisonment is a state agency, and the wrong is incalculable and real, and it exists at the moment of wrongful incarceration and continues until a person is exonerated. And so that's my position with respect to perhaps an action against the locality. Also, if you look in the resolution, there is a mechanism that we set forth for a set-off to the state in the event Mr. Clark were to pursue a claim against, for example, against Floyd County. So he would not enjoy a bounty. And I can't imagine it being called the bounty. But what some people might have called in the past a double recovery, and I would not call it a double recovery either. Any amount that Mr. Clark receives is just, in my opinion.
Thank you. A further question, if I may? So thank you for your explanation. The frustrating thing is the originator of all of this will not be held responsible to you, and that is what I find so troubling. I understand it coming at the state level, we're like the last resort, but to our local counties, and it is just this is why we have these cases before us, for failure of local governments a lot of times, and I think that's a serious issue that also needs to be addressed by us. We're not attorneys, and my final question, Mr. Chairman. So I read the state board, the actual advisory board names, and they all had a designee, and I'm curious as to whether or not these designees were attorneys or what was their role. So, for example, I'll read you the state Secretary of State Brad Raffensperger with a designee, Commissioner Russell McMurray with a designee, Commissioner Tyrone Oliver with a designee. And so my assumption in reading this is I would have done that too if I weren't an attorney. So I'm curious as to the makeup of the ones who actually made the decision.
I cannot say with certainty, but I know that the Secretary Raffensperger's designee introduced herself as having legal training. The person from the Department of Corrections who recused herself from the decision struck me as an attorney, and I believe she is an attorney. And so I'm of the mind, but I'm without certainty, that the majority of the people who were serving on that board had legal training.
Thank you. I know that Regina Quick, a former colleague of ours, is an attorney. So I was just curious as to how that makeup of the board worked and trying to understand the reasoning. So thank you, Mr. Chairman.
I think we're going to phone a friend here for a second. If you will introduce yourself.
Yeah,
Right.
thank you, Mr. Chairman. George Ray with Nelson Mullins. We're pleased to be able to help the Georgia Innocence Project through these claims, and particularly Mr. Clark and Mr. Watkins. In most cases for the Claims Advisory Board, the commissioners and the actual named participants send their attorneys or general counsels because of the complex natures of these claims. So each of the individuals that participated this year were, I believe, the general counsels for those commissioners. So they were all lawyers in this case.
Chairman Parsons.
Thank you, Chairman. I wanted to say I appreciate what y'all brought to us. I appreciate your words that you brought to us. Thank you for that. The way I look at these always is my job here today is to vote on the resolution that's before us. That's what I have to vote on or to amend or whatever comes up. I can't imagine those years that were wrongfully taken away from you. I really can't. I know, and I hate it for you. I really do. And I certainly will do anything I can here today to help get this passed and get you some compensation for that time. And you know what? I know that you have received a lot better advice than I can give, and you'll get a lot better advice than I will get in the future. if this passes the way it is, you're going to get some money, I mean, to begin with, and besides the annual disbursements. But I would just want to say this as an old grandfather, and I know those years were wrongfully taken away from you, but you're not as old as you think that you are. You still have a whole life ahead of you, and I would just advise, and you'll get a lot better advice than I can give you, but I would hope and advise that you take some of these funds, and you can be trained in any number of things, and you're young. I mean, you are. I mean, I know you don't think that you are, but you are, and you can be trained in any number of things, in any number of ways to live out your life and be happy and live a successful life. And that's it. And I'll do anything I can to certainly help you here today. Thank you.
Thank you.
Thank that, Chairman Parsons. Any other questions, comment from the committee? Chair Lady Smith,
At the proper time, I'd like to make a motion.
this would be that time.
Thank you, Mr. Chairman. I move that we accept and recommend the compensation of $1,840,715 as suggested.
I'll second
So
that
moved.
motion, Mr. Chairman.
We have a motion and a second. At this time, to handle this properly, I'm going to offer an amendment to House Resolution 901 LC 339603 on lines 1, 9, 22, 86, 92, and 103. The spelling of Darrell, D-A-R-R-E-L, is changed to D-A-R-Y-L.
Is that the right spelling?
Is that the right spelling?
Yes, sir.
All those in favor of...
If I may, before
Yes.
the motion passes, just a point of clarification, the amount that we were talking about is $1,840,715. I believe that it might have been just a misarticulation of that in connection with the motion.
Just to answer the gentleman's question on line 86, the amount is correct.
Okay, thank you.
All right, so we have a motion and a second to amend. Do I hear any further discussion on that? Hearing none, all in favor say aye. All opposed, like sign. Hearing none, the amendment passes. We now have a motion and a second to pass as amended. Any discussion? Hearing none, all those in favor say aye. All opposed, like sign. House Resolution 901 has passed.
Thank you.
I will say again, echo what several of up here have said. Obviously, we can't undo what's occurred. There's still some legwork that will still have to be done here, but your presence here means a lot to us. We appreciate it. Not a comfortable thing for any of us, so I appreciate you being here and your efforts, and wish you the best from us.
Thank y'all for having me.
Sir.
Thank you.
We are going to move on to House Resolution 902 at this time. Please state your name and introduce yourself to the committee, please.
Good morning, Mr. Chairman. My name is Cameron Roberts and members of the committee. I'm from the law firm of Kaplan Cobb, and I've got the honor today of being here before you to represent Joseph Samuel Watkins, Joey Watkins. As you'll hear this morning, Mr. Watkins is a model Georgia resident who had his life taken away for 22 years for a crime that he did not commit. Joey was 22 years old when he was, or excuse me, 20 years old when he was first convicted. He served 22 years in state correctional facilities, and he's now 43 years old. As with Mr. Clark, he is never going to be able to get that time of his life back. Now, despite his unwavering claim of innocence throughout these 22 years and before trial, Mr. Watkins was wrongfully convicted of felony murder and related charges in 2000. More than 20 years later, Mr. Watkins' convictions were vacated by a state court, which found that his trial had been tainted and his constitutional rights had been violated by juror misconduct and by the state's misconduct in failing to disclose exculpatory evidence and by objectively false testimony by an analyst for the Georgia Bureau of Investigations. The the habeas court, that was the Superior Court of Walker County's decision vacating Mr. Watkins' convictions, was affirmed by a unanimous opinion of the Georgia Supreme Court in 2022. As you all have seen from the summary information before you, the resolution itself, and the Claims Advisory Board recommendation, Mr. Watkins is respectfully requesting that the General Assembly pass this resolution and compensate him in the amount of $1,620,986.27. Very precise number for a very hard to value injury that Mr. Watkins has suffered. I would echo everything Mr. Murphy said about the challenges of compensating an individual under these circumstances. And as I mentioned, that's for 22 years in 1 month and 22 days in prison. I believe the Claims Advisory Board's recommendation, which it sounds like the committee has read, which very much pleases me, ably summarizes what would otherwise be a quite lengthy record in this case, and I don't want to dwell on it. I will just point out a few things about Mr. Watkins' case. First is the case really should never have been brought. There was conclusive cell phone evidence that placed Mr. Watkins nowhere near the scene of the crime at the time. You've probably heard about cases involving cell phone evidence as being inculpatory, as showing, oh, this person robbed these locations. Well, here, the cell phone evidence, which was absolutely undisputed, showed that Mr. Watkins could not have been where Isaac Dawkins was murdered in his car. So the case really should never have been brought. Mr. Watkins had no opportunity to kill Mr. Dawkins and no motive to kill Mr. Dawkins. To make up for that lack of evidence, the state prosecutors in this case essentially invented, I'll use the word invented, a motive to prejudice the jury in this case by claiming that Mr. Watkins had not only killed Mr. Dawkins, but also killed a dog and placed it on Mr. Dawkins' grave. Now, the state engaged in a series of misconduct related to that grave dog evidence. They failed to disclose evidence of a bullet that had been recovered from that dog, and the GBI analyst gave what the court found was objectively false testimony that a medical examination essentially, of that dog had never been made when it in fact had been made, as the analyst knew. The third thing that happened in this case is that a juror improperly over the weekend during deliberations decided to conduct her own drive test, essentially trying to see whether she could do the route that supposedly Mr. Watkins would have had to have done. She erred in any number of ways in trying to recreate that, and I don't think I need to explain to the committee the problem of having a juror engage in that. For all three of those reasons, the Superior Court of Walker County vacated Mr. Watkins' conviction. Now, we are here seeking compensation, as I said, in the amount of $1,620,986. The Claims Advisory Board recommended payment for Mr. Watkins, based especially on the misconduct by the Georgia Bureau of Investigation analyst. I would still echo everything that Mr. Murphy said regarding, and that Mr. Mitchell said as well, about really innocence being the kind of key factor here, and whether there's misconduct by a state actor, a secondary factor. But at least in this case, there was a misconduct by a GBA analyst, as the court found. The court, the board found that the amount that Mr. Watkins is seeking was an appropriate amount to compensate him. And they found that it was in line with other state statutes and the amounts that other states compensate the wrongly incarcerated. And I'll echo what Mr. Murphy said, maybe go into a little more explanation on that point. We looked at neighboring state statutes, including Alabama, Florida, Mississippi, and North Carolina. Now, those are quite dated at this point in many cases, but they award $50,000 per year. We took an inflation adjustment of that and took the low end of those inflation adjustments to come up with the amount of $72,000 per year. By a more recent statute that was adopted by Texas compensates the wrongly incarcerated at $80,000 per year. So this is like the board found, well in line with that. And based on this committee's actions with Mr. Clark, I take it that the committee largely agrees with that. So I won't harp on it any longer. I also will invite the questions of the committee, but first I do want to allow Mr. Watkins a chance to address the committee as well.
I'm going to kind of piggyback off of what Lee said. Coming out of prison after you spend all your youth in prison and all these years, the majority of us don't have trades. I was lucky. I started my trade in the automobile industry at a young age, and I was lucky enough in my later years of incarceration. I worked for the Georgia State Patrol, so I got to get a lot of training. So cars are kind of my life now. My family, they spent every bit of money they ever worked for, everything they ever had trying to get me home. And, that when I got home, I came home to a failing business. My dad was in debt. COVID messed him up and everything kind of went down. So probably 2 months after I was home, my mom got sick. She started having health problems, so she can't work now. She has seizures and a few other things. So then probably 2 months after that, my dad had heart surgery. So now he can't help me. His business is done. I can't, I'm kind of starting from the ground up, and like Lee said, all I know is the automobile industry. Where do I go? If I can't work there, where else can I go? What can I do? It's hard coming home after all these years being the primary caretaker for your parents. When I left, they were younger than me, my age. And now I'm home trying to take care of them, and it's hard. What do you do? Medication, this, that. The business is not good. It's just, like you said, you're kind of lost. I don't have this messed up opinion about the state, about law enforcement. I don't have that because, there's an old saying, one bad apple shouldn't ruin the whole tree. But at the same time, who's accountable? Who's to blame? I don't know. It's just hard coming out and trying to start over at 43, 44 years old. We don't have time to build like Lee, I don't have any kids. All I have is my mom and dad. And we really don't have time to build a life, so to speak. What do I do when I hit the age where I can't work? What if I start having health problems? What do I do? I don't have many options, But it's hard, and even if we don't end up getting any money, maybe this will change something. Maybe somebody will look at this and say, hey, maybe this will help somewhere along the way. I don't really know what else to say. it's just hard.
If anyone has any questions, I'd be happy to answer them.
Well, thank you. And thank you again for being here. I know we said that in the last resolution as well, but it does mean a lot. And which begs the question, as we talk about, as the chair lady spoke about in the last resolution, it's shameful that the people that are dealing with this aren't the ones we're having to deal with or having to punish. In this case, the GBI, would love to see, them sitting in front of us at the same time, having this conversation about their involvement. But we're not a court, and the courts have already kind of dispelled with your situation as they appropriately should have. I don't have any further questions. Representative Mitchell.
Thank you, Mr. Chairman, and once again, I think this highlights the flaw in Georgia law. I think once again, Mr. Watkins, I think you were well represented. I think the juror misconduct, the buried evidence, the false state testimony, those things are compelling, but I don't even think those things should be before us. The key factor is the rulings by the Georgia courts. The Superior Court vacated the convictions, finding, among other things, that the GBI testimony was both false and misleading. Georgia's Supreme Court affirmed the Floyd County DA sought dismissal of all charges, and Mr. Watkins was exonerated. So I think he's more than deserving of the $1,620,986 and 27 cents. Mr. Watkins says that maybe something should be done. I would hope that the members of this committee would join an effort to come up with a just compensation laws for those who have been falsely and wrongly convicted, so that we don't have to go to these extremes. The fact of the matter is, as I'm sure most of you are aware, very fortunate for these two applicants, they had a representative that had the stature of Representative Dempsey in the right party, because there have been compensation resolutions that have not gone as far because they don't have the stature of a Representative Dempsey. I think that is absolutely wrong. We should come up, as the majority of states have. If you're wrongly convicted and the courts have said so, then they should be justly compensated for that.
Thank you, Representative. No more questions. I think if the committee will indulge me, I'm going to have Chair Lady Dempsey, if you don't mind, you want to speak? Okay, I'm sorry. I wasn't certain when you were perfect. We have not. What's the pleasure of the committee? Chairman Prince.
Mr. Chairman, I'd like to make a motion that we do pass this resolution.
There's a motion to pass. Second. Chair Lady. All those in favor say aye. Aye. All opposed, like sign. All right. House Resolution 902 has passed, and we'll move on from here.
Can I have a quick comment?
Chairman Prince.
Thank you, Mr. Chairman. And this gentleman, I wish we could do more. I mean, I think we all do, but on behalf of our state and our systems, we want to I'd like to apologize for what has happened, and ask that you continue to lean on God. His strength will make sure you're strong. Sorry. Thank you, Mr. Chairman.
Representative Mitchell.
I was just thinking here, maybe this question is for the attorneys. There was jury misconduct, there was buried evidence, there was manufactured evidence, which are all crimes. Did the DA's go after those who committed those crimes that place both these applicants here?
No, unfortunately, not to the best of my knowledge in any way.
So, there's something else that this body can do, is we can refer this evidence to our district attorney and see what he wishes to do with this, because these are crimes which led to the wrongly conviction. And the chair lady mentioned, we wish something could happen to those who caused this. Referring this to the district attorney for his investigation may prove fruitful.
I appreciate those comments. Again, I'll echo everybody's sentiment up here. I appreciate you being here. Wish we were not meeting under these circumstances. Wish you all the best. And with that, Chair Lady Dempsey, I think, would like to come up and say a few words.
Thank you, everyone.
Thank you, gentlemen.
Thank you. Thank you. Thank y'all for your kindness, for your wisdom. I think you made a good decision, really good. But I want to speak to just a couple of things that have been brought up here that are very important. I want you to remember that last year, as a House, we passed HB 364, which is to deal with exactly this, Representative Mitchell, exactly, to make this where, as legislators, we are not in this spot. It is in the Senate. Might be a little bit stuck. So each of you who have sat here today also join me, I'm sure, in wanting to try to help that move forward. I think it can. It was a true honor to be a part of this. I have not, and I'm in the tired budget phase right now. That's why this is happening. Last night we had a 4.5 hour following a 3.5 hour, hearing, just like y'all are going through right now. So forgive me for having tears. But I want you to know, I learned a couple of things in this that are important for each of us to wrestle with. There's a very different assimilation process from being exonerated or from completing your service. And I think we need to explore that. We really do. When you leave having finished serving and you move back into a community, there are a lot of resources that come with you to help you integrate back into that. When you're exonerated, you walk out with your freedom, but with the need for exactly what y'all have voted to support today. To revisit, what keeps coming up, too, is that those who actually inflicted this are not who are here today, as they should be. And I've wrestled with that. As I told you, I know them. I've worked beside them in my community, even the GBI agent, and it breaks my heart. Both of these cases are very intertwined by many of the same people that inflicted this. From the county level to that GBI level, it is very, very painful. At least one I know is not alive, probably others. But what is also very sad is to realize that some of those were raised in higher elected office, were given bigger appointments, made bigger salaries, and today probably are receiving bigger retirement packages because of that. And that is something that I hope you will all join me and help me work to see what we can do to change as well. So I just want to say thank you. Thank you.
Representative Mitchell.
Yes, thank you. Thank you, Mr. Chairman. I just want to say, Chair Dempsey, your constituents should be very proud of you. You have certainly, you represent your constituents so very well. And I just wanted to publicly thank you for the job that you're doing for your community.
Thank you.
Chair Lady Smith.
So essentially, I could say ditto, but to those of you who benefited from all the energy and time and passion she's put into this, there's a whole lot of energy packed into a very tiny, powerful young woman. Young woman.
Thank you. Agree completely. Thank you for being here. Thank you for championing this for them. And with that, we will stand adjourned.
Thank you.